Our next guest is Mr. Willem Meuwissen, an expert negotiator, mediator, and litigator in commercial, corporate, and real estate law. He is the author of several publications in commercial law and mediation. He teaches negotiations and mediation at the Bmediation Accredited Mediators Course and at AIA European Mediation Training for practitioners of justice, at the Belgian National Magistrates Training Institute, at the Brussels Diplomatic Academy of the University of Brussels. He teaches international economic negotiations and conflict resolution. He is a permanent member of the Belgian Federal Mediation Commission and a member of the Flemish Bar Association ADR Commission. In partnership with Beir Van Raes Co, he created Agrementor, a law office established in Antwerp and Brussels, specialising in interparty conflict resolution such as negotiations and mediation. I'll request Mr. Willem Meuwissen to kindly come and express his views. Thank you.
Thank you. Mr. Chief Justice, Mr. President of the NCDR, ladies and gentlemen of this very distinguished assembly, it is an honor for me and for my colleague Philippe Billiet to be here today, here in Pakistan, coming from Belgium and being able to address you on this very interesting issue, what mediation is. As far as I know, I have prepared a PowerPoint presentation which now should be projected, but unfortunately I don't see it behind me, and there it is. Thank you. Oh yes, okay. Okay, ladies and gentlemen, I prepared a PowerPoint presentation, and as a lawyer and a member of the bar, this presentation turned out to be a lot too technical and not interesting enough for an assembly like yours. So I shall adapt myself and I shall tell you the essence of the presentation I prepared for you. I want to address this assembly on international commercial mediation. Pakistan is a country which is a member of a group which is internationally called the Next 11. The Next 11 being the countries who in the 21st century will move on to become the most powerful economic countries in the world. You have at this moment 191 million inhabitants. Belgium has 10 million. Your population is young. You are active in all kinds of science, trade, economic activity. It's on the screen, thank you. Thank you. So, your international contacts will grow exponentially, and when international trade contacts increase, so do international disputes. And now it is so that mediation is perfectly fit for resolving international commercial disputes. And I shall try to explain to you why that is. But first of all, I want to show you that mediation is not something which is hanging high in the air, but that international mediation is already well grounded in international legal texts. First of all, you have within the framework of the United Nations the ancestral model law on international conciliation. This model law aims at offering to member states of the United Nations a framework to develop an own domestic legislation on mediation. And I understand from the persons with whom I have been talking today and my distinguished colleagues from here in Pakistan that this model law is already being used as a source of inspiration for a Pakistan mediation law. And coming from Belgium, where we introduced in 2005 a mediation law, I can assure you that the introduction of legislation on mediation greatly increases the use of it. And after 10 years, we are now revising this law, and both Philip and I are involved in that restatement of the Belgian mediation law. Belgian mediation law, which also is inspired on this ancestral model law on international mediation. Further sources of international mediation law are the general principles of private international contract law, which is actually national law, and in Europe, being an important trade partner of South Asia, we have the European Union Mediation Directive. And this directive lays down the fundamental principles of mediation legislation in every European member state. So the 28 member states of the European Union have adapted by 2011, so since 5 years now, their national legislation to this European Mediation Directive. Every text that lays down fundamental principles is always useful and interesting to consult when you want to inspire yourself to create an own national legislation. And finally, mediators are already active across the world, and they usually belong to mediation organizations which are internationally active. And these mediation organizations all have their own codes of conduct. Now, when you want to know what a mediator should do and what a mediator must not do, it is enough to consult all these different codes of conduct, which already display what the perfect profile of a mediator should be. I see that I have gone too far in my presentation, so I have to turn back. This is for the international codes of conduct. Oh, yes. It works there, but it doesn't work here. And this, okay. Secondly, there are institutes, the International Chamber of Commerce in Paris, the CPR institution in New York, the American Arbitration Association, but here, very near to your door, an absolute international economic power, being China. The People's Republic of China has a very well-known mediation center established in Beijing, and which is part of the Committee for the Promotion of International Trade. And this mediation center is located in Beijing and has subsidiaries all over China. And finally, of course, there is the Chartered Institute of Arbitrators in London, who also have mediation regulations, which mediation regulations are also a source of inspiration for anybody who wants to establish a legislation in legislation on mediation in its own country. What is mediation? Mediation is very generally spoken a process whereby parties request a third person to assist them in their attempt to reach amicable settlement of their dispute arising out of or relating to a contractual or other legal relationship. So there are at least two parties, they have a conflict, and they want to settle, their conflict amicably. And in order to help them to do that, they consult a mediator. And specific for a mediator is that he does not help parties settle based on facts or rights, but that a mediator helps parties to make an interest-based analysis. It are the interests behind the rights and behind the facts which are the moving forces towards a settlement. When you are able to look together, when the conflicting parties are able to look together at their own interests and to try to match these interests with the other side's interests, you have a setting where you can find an intelligent settlement which is much better for the parties than any court ruling may be. And I shall try to explain that to you further on. There is also, of course, a definition of mediation in the Mediation Directive, I should say a word about the semantic difference between conciliation and mediation. Conciliation is usually done by a person who is a judge, for instance, a person who has the power to decide. And before taking the decision, before imposing his decision on the parties, this judge or arbitrator tries to help the parties to reach an amicable settlement. And this is usually known as conciliation. In conciliation, however, there is what is generally known as a strategic barrier. Parties are not putting on the table all their interests and all their information because they want to keep a good attitude towards the person who ultimately is going to decide the case, would they not find an amicable settlement. This is called the strategic barrier, and this is why mediation is to be preferred over conciliation. When is a dispute international? Well, it's very simple. There are very technical explanations about that. But to put it simply, it is self-evident a mediation is international when there are parties involved from different countries. And in international trade, these countries may be very far apart. These countries may have huge language differences, cultural differences, differences in commercial habits. So conflict in international trade is always lurking around the corner. I shall skip the next slides, which are merely technical. And why would parties and their attorneys be enthusiastic to consider mediation? First of all, in mediation, you do not go and look for international competence or applicable law. Lawyers may spend 5 or 10 years finding out which judge is competent to judge the case and which law this judge should apply. This is a matter which, in the framework of mediation, can be avoided. But most of all, it are the parties, ladies and gentlemen, who know their conflict best. They know their conflict much better than any judge or any arbitrator ever will. And not only do they know their conflict best, do they know what has happened, but they also know best how it should be optimally resolved. And when they succeed in putting this knowledge together, they are able to evolve towards an optimal settlement. And this is why it is so important for the parties to keep the solution into their own hands, to go to inter-party conflict resolution rather than to supra-party conflict resolution. In supra-party conflict resolution, a third party takes the decision in the stead of the parties themselves. And this should be done. I mean, this is inevitable. I mean, it is important. It is of paramount importance to have a very high quality legal and court system in the country, have a very strong judicature. This is very important because when parties do not succeed in settling, they need to know that they can go to the court and that the court will hear them and will take a good and rightful decision, but the court will always take that in their stead. So good mediation goes together with good judicature and with good quality arbitrators. It all is part of the same quality solution of conflict. When parties succeed in resolving the conflict themselves, they can introduce, and this is very important, I think, business-wise solutions. When you go to a judge can terminate the contract and can condemn one of the parties to an indemnity to pay to the other, but a judge can never create a new way of cooperation. When you have a business conflict, it is much more intelligent to sit down together at a table and to try to find a creative business-like solution, because this solution will be economically much more beneficial than any court ruling may be for anybody. So it is important that the creativity, the business creativity of parties be introduced into the conflict resolution, and mediation is a very good means of doing that. Preserve the business relationship. Ladies and gentlemen, the businessmen here in the room know how much it costs to develop a valuable business relationship. When you know your business partner, when you can trust one another, and when you have a conflict with such a business partner, and you take one another to court, this means that you break up this valuable business relationship, which has cost you so much energy and money to create. And the first victim of a court proceedings, unfortunately, is always the business relationship. So mediation is very important to keep this value of the business relationship into your balance sheet. And finally, ladies and gentlemen, mediation allows parties to act swiftly, discreetly, and cost efficiently. Swiftly meaning that when you have a complicated international business conflict and you start mediation, it will take you 1 to 3 months to have it solved. It won't be cheap because mediation, unfortunately, is not cheap, but it is cost effective. In mediation, the decision makers of the company need to come to the mediation table. They need to be present. They need to be there. They need to invest their management time in the resolution of that conflict. This is not cheap. They are accompanied by their own experts, by their legal and technical experts. The creation of such a negotiation team is not cheap. And it is not cheap to fly this team in some neutral venue, about which I shall address you in a few moments. But it will be cost efficiently, because when you have to take one another to court for 10 years, it will cost you endlessly more. And finally, mediation is discreet. Your business conflict is not out in the street. Your business conflict is not known to everybody and is not known to persons who want to be present in the courtroom and hear and enjoy how you are quarreling with one another. All this is avoided while being busy by resolving your conflict in mediation. I shall say a short word about the documents which are necessary, the legal instruments in international mediation, and they are the mediation agreement and the mediated agreement. And the mediation agreement, and I shall skip this because this is a difference between civil law and common law, which is very interesting and which is very important, but which is too technical for today. Important is when you mediate, you lay down your mediation activity in a mediation agreement, which is concluded prior to starting the mediation. And here it is important that you find a neutral venue for your mediation. This is where the flying in of the negotiation teams comes about. What is a neutral venue for a business dispute between a Belgian company and a Pakistan company? Well, we can say, you Pakistani, come to Belgium. We give you a warm welcome. And the inverse will be true too. You can say, well, you Belgians, come to Pakistan. We will give you a warm welcome. So a mediation will be performed somewhere in between, making all the parties make the same investment in travel and spend the same amount or a comparable amount of costs. Very important in international mediation is also the language issue, and along with the language issue, the culture issue. In international trade, there are huge differences in language. People have not understood each other, and because they haven't understood each other, some conflict has arisen. Or the parties have different cultural backgrounds, and one party has offended the other without even knowing it. It is important that when you are resolving the conflict, that the mediators know all this, that they know not only the lingua franca of international business being English, but that they also know the local language, the language of the parties. So here you see that in a truly international dispute, co-mediation between mediators from the backgrounds of each party are very helpful and are useful and are even necessary, if you ask me. You may make a choice of law in your mediation agreement because you will ground it somewhere, and usually that will be the law of the country of the mediator. What happens when there is no choice of law in the mediation agreement, I shall reserve for another time. When you have a mediated agreement, a settlement, The question is, where will it have to be performed? And this needs to be taken into consideration. And not only where is it to be performed, but is it executable? Your settlement agreement must be drawn up in such terms that it is executable by what we in Belgium call a court bailiff, who will seize goods and sell them publicly if necessary. I mean, an enforcement of the mediated agreement. And this needs to be addressed in the framework of the drafting of the mediation agreement. I shall skip all this. This is very interesting, I can assure you, but it would be too technical and it would take too long. The matter of enforceability is very important and is now being addressed by the UNCITRAL, which is making a new international law on the enforcement of mediated agreements, of settlement agreements, which is also very important, internationally spoken. So also this part of an international conflict resolution is being usefully addressed. Ladies and gentlemen, I shall terminate now my intervention. I think that when I look at your country, which is rising fastly on an international field, where trade and industry are rapidly growing, where your international contacts will need to be adapted to this growth, I think that international business mediation might prove to be a very useful tool to enhance all that. I thank you very much for your attention.